Randolph Phillips argued more cases than some lawyers. Before he was 40, he already gained a kind of notoriety, but his persistence paid off with 2 pro se appearances at the United States Supreme Court. Phillips was born in Manhattan in 1911. In 1943, the New York Times reported that he was a conscientious objector for religious reasons, which the draft board rejected. He helped the ACLU with similar cases. Toward the end of the war, he began decades of complaints against railroads over stock plans, mergers, and their board members. It's difficult to track some of these cases because of how many times they were filed in various courts for different causes of complaint. By 1947, while appearing at a Senate hearing, he was called a professional strike suitor, and his father's last name, Moses, was brought up in what was read by most present as an anti-Semitic or anti-communist attack. Phillips explained to the Senate committee that his father had died when he was age 2 and he had assumed his mother's last name. Also in 1947, he was reported to have lost 3 appeals to bring a case in front of the Supreme Court. The next year, he complained that 2 justices should have disqualified or recused themselves. In 1953, he married the cartoonist Lily Renée. Lily's family escaped Austria in 1939. There's actually a good amount of information about her online already, including a YouTube video which I'll link in the description, and a 2011 graphic novel. In 1954, Randolph Phillips appeared at the Supreme Court for the first time in the case General Protective Committee v. SEC. He helped win the case. There were no audio recordings of Supreme Court arguments at this time, so I don't have that for this case. Next year, Phillips helped a group of stockholders win over $1 million settlement against Pennsylvania Railroad. At this time, he is called a proxy expert in the press. There were changes in his professional world. Phillips began litigation against Robert Young, his former mentor. Time magazine suggested that it was because he was denied a new job after the 1955 case. In 1957, that case reached the Supreme Court as Allegheny Corp v. Breswick & Co. A follow-up to that case reached the court in early 1958, but was not argued. The court sided with Young, but he would not live to see it. The Times noted Young's depression, but named Phillips in his case as one of the reasons. In Randolph Phillips' obituary in 1982, the New York Times would write that he argued before the Supreme Court in 1958. I don't think this is correct. First, because we already know that he argued or appeared at the Supreme Court in some fashion in 1954. Then in the 1957 case, he is not called on in the oral arguments.
Mr. Seymour.
May it please the court, my taking 40 minutes for Allegheny and opening the case, Mr. Gannan taking 25 minutes for the Interstate Commerce Commission, Mr. Levin taking 15 minutes for the preferred stockholders, Mr. Kahn taking 2 minutes for certain common stockholders.
Mr. Gannan.
May it please the court.
Mr. Gruss.
Mr. Levin.
Oh, Mr. Levin. Yes, excuse me. Mr. Can.
Mr. Chief Justice and Justices.
Mr. Brussel.
Chief Justice.
Phillips may have submitted written arguments in that case or in the 1958 follow-up, but the record is still very unclear. Phillips returned to stockholder complaints. In 1962, he was warned that he could not argue pro se to represent his mother-in-law. He challenged each of Nixon's nominees to the Supreme Court. In May 1972, he placed a full-page ad in the New York Times calling for Nixon's impeachment over Vietnam. The Watergate break-in was still in the planning stages. That September, he was ordered to register with the campaign finance organizations. In 1975, he argued that President Ford had been illegitimately appointed as vice president. This was perhaps his last attempt to reach the Supreme Court for a third time. He died in 1982. His papers are at Columbia University. If you want to hear more episodes about people representing themselves at the Supreme Court, please like and subscribe. United States Supreme Court rules and practices have changed since these cases. This was a podcast episode, not legal advice.